All right. Well, the next, we have one special report from the Client Protection Board annual report. Board Chair Carrie Umlawn. Do we have her available?
Not yet. I've not seen her log in.
Okay. Well, then why don't we go back to our discussion on the resolution, and then if she does come, then we may take another recess to accommodate her schedule as well, and then we'll follow that with a legislative session report. Okay, so we have an amendment from Governor Williams Ruth. Maybe if we can restate the motion for the amendment.
I also have it redlined if you want me to share that. I could share my screen briefly so people can look at it. And
Okay,
Governor Williams Ruth can confirm that I've got it accurate.
that would be great. And then I have Governor Angeville, Governor Abel, and Governor Knight in the queue.
Does that need to be bigger or is that fine? It needs to be bigger. Okay. And Governor Williams Ruth, please let me know if I've redlined it incorrectly.
Okay, Governor Angeville.
Thank you, President Cicchetti. I first want to start by really thanking my fellow co-chair of the Diversity Committee, former Governor and now Judge Jarman, for her very well-reasoned and impassioned presentation on this issue, as well as Jordan Couch, who really gave us a very instructive few minutes about the background behind what we're talking about, which is really important. I just want to say briefly that I support Governor Ruth Williams' amendment. However, if the majority, which I believe is going to take this position, if the majority is insistent that we need to have a clause that supports the continued requirement of passing a bar exam, I would urge that any references to diversity disproportionate impacts are taken out of the resolution. And the reason why I say that is not that I don't think that folks who are behind this resolution don't care about diversity, but I just think it's not right when you have the diversity committee and you have other stakeholders who haven't been consulted about this. And the implication is that a bar exam doesn't disproportionately affect people of color or people in diverse communities. I think that, throwing in the word diversity when you want to get something is not a good way to go. I think we need to use all our words carefully. So I would just urge that if we are not inclined to support the amendment made by Governor Williams Ruth, then I really ask that we take out all references to diversity and inclusion in this resolution. Thank you.
Governor Angeville, would it be appropriate if it sounds like this is a kind of a conditional request? Yes. Would it be appropriate that we continue on our discussion for this amendment? If it fails, then you might bring another amendment to address your concerns?
Yes, thank you, President Cicchetti. That is what I will do.
Thank you. Okay. Governor Abel.
Well, thank you, Mr. President. So when I spoke earlier this afternoon in favor of this resolution, one of the items that I identified as being attractive for me with this resolution was that I really think this was crafted with care. And I think it is, as it currently exists, is balanced. And I think it sends a couple of simple messages. And one is that this board stands for the proposition that a bar exam is and should be part of the process for entering into the profession. I don't think that's a particularly controversial position within this board. We've taken that position fairly recently. The other one was that we support improvements to the bar exam to make it a better bar exam for the profession, for the protection of the public. And that's what the resolution as originally drafted does. Governor Angeville just made, I think, the appropriate and important point that we have to be careful with our words in our language. And this language that's inserted, a new method of admission, I think with respect to Governor Williams-Ruth, I think that basically says the opposite of what the original draft of the resolution stood for, which was that we support a bar exam. And I'm not sure what a new method of admission would be. I think it really raises more questions than what it answers. So in my mind, the resolution as amended actually stands for, in many ways, the opposite of what the resolution stood for originally. I like the original resolution. I think it's simple. I think it's clear. I intend to support it. So as a result, I would oppose the language to amend it. Thank you, Mr. President.
Thank you, Governor Abel. Governor Knight, you had your actual hand up before Governor Williams-Ruth. Are you still interested in speaking?
Thank you, President Cicchetti. I respectfully oppose the amendment. I think the amendment, as Governor Abel indicated, does a 180 on the resolution. It is not a resolution in favor of, abandoning an exam and imposing a mentorship or apprenticeship program. This board is not advocating for an apprentice way of becoming a lawyer. I think this board is saying, one, some type of measure of competence is important to protect the public and give the public confidence. And two, how that bar exam is structured, both the form and the content, should be reviewed to make sure there's no discriminatory effect. I do want to comment very briefly on Governor Angevel's comment about language of diversity and inclusion, and where we got that language. The language, examinees of color and first-generation examinees, comes directly from the Supreme Court's order and the charter establishing the Washington Bar Licensure Task Force. That's the Supreme Court's language, not our language. I thought it was appropriate to mirror their language, certainly open to any other suggestions, but that's the language that establishes the charter. So I think it's appropriate to include that language because it is what the charter directs the task force to do. I also think it's appropriate to include that language because if we don't, then all we're saying is we support the continued requirement of a bar exam and we don't support reviewing it to ensure there's no discriminatory effect. That's a very important part of this resolution, is that although we think a bar exam is important, we absolutely want to make sure that it is reviewed both in content and form to make sure there's no discriminatory effect. So I think we need to leave that language in, or a similar language in as well. Thank you.
Thank you, Governor Knight. Governor Williams-Ruth.
So I disagree that it completely pulls a 180. I mean, having left specifically bullet point number 3 that encourages the review and possible change to the format, but it makes it where I really am trying to draw an appropriate corollary to something else. And what's coming to mind is climate change. If this task force has every social scientist, bar examiners come forward and say that a bar exam, using that term, bar exam, is impossible to separate it from its horrible origins, and we therefore move forward into a practicum, or as one of the suggestions that I'd heard, more like a medical school thing where you go through your classroom work and then before you're allowed to go out on your own, you have to do a residency or something along those lines. So I like, not only do I like the amendment because it opens the possibility that there are things that we've never even considered, and that to stick to the phrase bar exam, I really believe that we are on the precipice of an entire modification of the legal world, including changing to the licensure structure. I mean, again, wasn't a top 10 graduate of my class, so I can tell you that when I walked in on my first day of my first job, I had no idea what I was doing, other than I was great at rote memorization and was able to sit there with my Barbary book that I read cover to cover, made my flashcards, did every practice exam that Barbary gave out, and I got through and passed the exam back in the days when they don't even tell you your score. They say you either passed and you only got a score if you failed. So I don't know, I could have done really well, or maybe I eked by half a point. Not sure, but I've been a fully licensed practitioner since June 2002 when I was sworn in. So, you know, it's really funny because there's been an invitation for us to modify this to make it acceptable to more, but yet now that we've come up with a proposed language that says, hey, we're still wanting to have some type of, and I'm going to use the word bar as to like a bar as opposed to an exam, that, you know, we're leaving behind this specific exclusion that we do not want diploma privilege. That's right there in number 2. So I'm not sure, you know, if that was really just lip service about, oh yeah, let's work on crafting something, or if you actually mean it. Because again, I'm trying to get to a point where this is acceptable in the sense of, again, not even knowing what in the world is going to be coming out of this, but to have something where, you know, we're burying our head in the sand to an antiquated system that came from a horrible origin story, you know, it just makes me shrug.
Thank you, Governor Williams-Roof. Governor Grabicki.
Tara, can you put the red line back up on the screen again, please? Thank you.
I also emailed it out. So let me know when you would like me to take it down so you can see each other.
You can take it down. Thank you. All right, if you look at that language, it still says that we favor a bar exam. We also are willing to look at other methodology. We've already got the, you know, the Reading for the Law program that we've had for years, which is an alternative to law school. Are there other alternatives out there? It's worth at least taking a look at. And I think this acknowledges that there are alternatives out there, but we as an organization prefer that a bar exam, a fair and equitable and appropriate bar exam, remain in place. So I'm not offended by the amendment. I'm comfortable with it. I think that I'll probably vote for it. I don't think it's the end of the world, and I don't think it's a 180-degree turn.
Thank you, Governor Grabicki. Governor Angeville, I see your hand is still up. Is that Governor
Yeah.
Angeville?
Yes, thank you, President Cicchetti. And I just really have one last word on this, which really is, you know, again, we all agree words matter. Just because you put the words diversity, equity, and inclusion or lawyers of color into your resolution, that doesn't make it follow a commitment to those words. So I think you've heard from stakeholders from the diversity committee who are strongly opposed to this particular resolution, but in the alternative, I don't feel the committee will be very happy and stakeholders will be very happy if this resolution goes out with the words regarding diversity, equity, and inclusion as it's currently formed. Of course, the will of the board will be what it is, but I just want board members to be apprised of how it will appear and look to the relevant stakeholders out there. And you've heard from several folks, you know, from the diversity committee and from the Young Lawyers Committee. So I hope you consider that in considering the amendment that I suggested, which would be to take out those words.
Thank you, Governor Angeville. Governor Clark, followed by Mr. Couch.
Sure, Kyle, thanks. Okay, so my only point that I don't see in the reso that I would like to see is some sort of, I'm a statement about the Rule 6 program, because last year they really weren't treated fairly in my strong opinion. So I don't. I mean, okay, my statement's not really about this, but it's about. I mean, I mean. I mean, okay. So with like, I mean, some point four that whatever that they do, I think that we should treat people fairly, and yeah, with that. So, thank you.
Thank you, Governor Clark. Mr. Couch.
I just wanted to briefly address, because I'm hearing concerns from those who believe that an effective bar exam is essential for our profession. And so I wanted to address that briefly by saying, in addition to the study I mentioned earlier that showed the bar exam only decreased bar complaints by 1%, another study showed that having to retake the bar exam multiple times until you passed did not decrease your risk of future bar complaints. In fact, people who had to retake the test still had the same issues as though they had never taken the test. So what value is there in a test that rising to the level of passing it does not actually make you better as a lawyer? The best study we have, the LSAC study, which looked at the correlation between law school admission testing, GPA, and effective lawyering, which is tied to bar passage rate, GPA is, showed there was absolutely no correlation between any of the standardized tests that we are doing and lawyer effectiveness. So for those who believe that an effective bar exam is essential for our profession, let me ask how we've survived this long without an effective bar exam. Thank you.
Thank you, Mr. Couch. Hold on. Governor Angeville, is your hand still up or is that left over? Governor McBride.
Thank you, Mr. President. I'm opposed to the amendment. I just have no doubt listening to this entire conversation that the argument for the elimination of the bar exam is going to be made. It's going to be made passionately with a lot of information. It's going to be made in the task force. What I question is, realistically, do you have the same confidence as my fellow governors that the argument to retain a bar exam that protects the public and deals with competency will be made? I don't think so. I think this is why we weigh in early to balance that discussion. And I'm actually more comfortable with the resolution at the end of this discussion than I was when it started for that reason, which is I think the best decision is going to come from exploring these parameters, not going in already having decided this is going to eliminate the bar exam. And so I think both for the amendment and ultimately no for the amendment and ultimately in support of the resolution. Thank you.
Thank you, Governor McBride. Governor Knight.
Thank you, President Cicchetti. Just very briefly, there's been some discussion on whether this amendment, fundamentally changes the resolution. I think it does. And I just want to point out, it changes the resolution from saying that, we support the continued requirement of passing a bar exam. So not committing to the bar exam in its current form, and changing that to a new method of admission that improves our profession through mentorship. That's just a completely different standard. And so I do think it's a fundamental change. If the board wants this change and is taking the position that we should have a mentorship-based admission to practice instead of an exam, then that's the position of the board. But I do want to be clear that the amendment fundamentally changes the resolution. For that reason, I oppose the amendment. But I'm enjoying and appreciate this discussion.
Thank you, Governor Knight. Governor McBride, is that a leftover hand or is that your hand again? Director Platchey.
I'm sorry.
That's all right.
Yeah, thank you. I just wanted to make sure that, and this is more to the folks serving on the task force, that Governor Williams-Ruth, Jordan, and Director Garcia, that we're not leaving some groups out. And I'm sure the task force has all this on their radar, but there are other ways into bars besides ABA accredited law schools and an APR 6 or some equivalent program. And I would encourage the task force to take a look at California's model There are much more less expensive law schools out there that are actually accredited by the California Bar that allow people to practice law. And I would hope that those folks don't get left out of the consideration as we're kind of thinking about how do we fit all of this in. And I would just encourage you to cast a wide net and make sure that you're not leaving folks behind and groups out as you're looking at this holistically, because Washington is not the only state. The way we do things is not the only way that other states do things. And access to justice, part of it is the high cost of law school. And there are alternative law schools out there right now, and I think they'll become more prolific as online education becomes more acceptable and is becoming more acceptable, of which the ABA does not even accredit right now. That are much more low cost. And if you take a look at California's model, you'll see many law schools accredited through the California Bar that are about a quarter of the cost of ABA accredited law schools. So please don't leave those groups out that are coming into the profession and may want to come and practice here. What do we do with them?
Thank you, Director Flacci. I see Governor Dresden, Chief Garcia, past President Majumdar, but we do have another guest that has joined us for the Client Protection Board annual report. Executive Director Nevitt, would it be appropriate to again suspend discussion on this particular item and proceed forward with that agenda item?
I think that's totally within your discretion to do, yes.
All right, and I'm going to do that because I do see, there's also some discussion about amendments to address the diversity issue and then the APR Rule 6. So there may be additional discussion with regard to that. So I have Director Plachey just went, Governor Dresden, Chief Garcia, and then past President Majumdar. I've got you on the list. If you would lower your hands, then I will not be confused as to who is raising their hands on the Client Protection Board annual report. And with that, we'll move to that.